peace.
Yes, Judge.
You're ready to go?
Yeah, I'll check on them. I know a couple of them were using the rest of them.
Maybe we have a few things to discuss first. Good morning.
All right, let's get on the record, please. In the state of Florida versus Demons, President and the defendant, this counsel, the assistant state attorney. Jury's in the jury. Yes, sir.
With respect to, there is, did you label it? Not quite sure what label is reflected in the record. So this particular state's proposed exhibit. But it is what appears to be a 121-page document reflecting extractions from the 9807 phone that are purportedly the discussions between that phone and Jamie King. We have already interposed our objection with respect to laying an adequate foundation for the introduction of this or any such exchange of text communications. We think that the state has not laid the adequate foundation. However, we also want to renew our objection to the fact that of this 121-page document, I think the state intends to assert relevancy as to a few of the pages, which renders all the other pages irrelevant and therefore inadmissible. There are instances in which the state has indicated that they believe their exchanges which provide context for that which they want to refer to, which is fine. That would make them relevant for context. But everything else coming in for the jury to just peruse through 120 pages of an exchange between the 9807 number and Jamie King is irrelevant, it's prejudicial, it's inadmissible. Beyond that, at page 52 of the exhibit, the court yesterday had indicated that the state should get rid of the reference to what purports to be a request from the 9807 number of Ms. King that said previously, get me a Glock.
That was after the murder in question, is my recollection.
That is correct.
Do you want to show the judge so he can see in context?
Yes, I'll hand it up in a second.
Here, we can put it on the screen. So everybody can know.
It's on that.
So if you recall, there was, after this, it included trips that Ms. King made to a gun store to purchase firearms. She sent pictures of various firearms to the defendant. Here, and I remind you, he was 19 years old at the time and an adjudicated delinquent for a firearms-related offense, so he was not allowed to possess any weapons.
Okay. That being neither here nor there. With respect to the argument that we're making now and the objection we're making, if the court sees right above that it says bring Mariah, and then it says okay, and then that previously said get me a Glock, like go now. If it's going to be out, then everything is out. But now it's saying get me, which is an entirely different thing. Now it's saying come and pick me up. And in the same way that messages might be included in order to give context, messages have to be excluded as to not give improper context. This is now saying, representing to the jury that he's asking to be picked up here. And we think that's inadmissible. The very next page, his next statement is, it's get me, and then his next statement is like now, then it says, I'll pay you, which is demonstrating some necessary urgency for him to be picked up and the fact that he'll pay for it to be done. I'm not sure how that will be contemplated, misunderstood by the jury, the context of the incident, notwithstanding the date involved. But we object to any redaction which will give a direct misunderstanding to the jury, a misimpression as to the communication that took place. You can't turn it from get me to a block to get me. It's turning from get me a gun to pick me up. It should all be gone if it's out. We can't deliberately mislead the jury.
Madam State.
Your Honor, I complied with Your Honor's request or order to take out references to any firearms on that in the discussion or the request of the defendant. In terms of the messages, that is what he said. It doesn't say what it was a gun or anything of that. They can say, they can put in get me item, whatever they want in terms of to make it clear in context. He's asking her to buy something, but does not say what it is.
Thank you. Well done.
Yes, Your Honor.
Take it out, just believe it. I mean, it's a firearm after the alleged incident in question, which the defendant is charged with. There's no connection with this element of the case. I'm allowing a lot of these text messages in just to show care, custody, control, and ownership of the phone. That's what it has always been about, and why I let the message in. You can look at the message in its context, circumstantial evidence as to who owns the phone, all right, and who's using the phone, who's controlling the phone, and therefore I allowed him in. But this is something talking about guns that happened after it. It shouldn't be there. I sustain the objection. Take it out.
It's redacted additional message on
I didn't hear you. I didn't hear you. I'm sorry.
No. So, in light of the fact that I'm losing my voice, my intent is to publish this in its entirety. So I would ask that with the permission of the court and the grace of the defense to let Ms. Smith help with the publishing of this.
Sure. So, no issue. You don't have this objection, that, do you?
No, sir.
That's fine. Set up there?
Yes, almost there.
For the sake of scheduling and efficiency, Your Honor, I'm not quite sure. I'm of the impression that this pedometer evidence that we object to, and to which my motion to exclude pertains, is about to come up in this session. And so I'm not sure if the court has had a chance to review the motion and the law that has been cited in support of it, but it might be time to have that discussion. Either that, or I'd like the state to be admonished not to seek to introduce that information until the matter is resolved.
I guess why is the motion filed July 9th? We're 2-3 months into trial already, and you filed July 9th.
As opposed to when?
Prior to trial starting.
Well,
hey, Judge, we have a hearing. This is demand for speedy trial. And you're in the middle of trial, the closing portion of the state's case. You're filing a motion saying, you know something, let's take a step back. None of this evidence should be admissible. All this should have been done before trial started.
I understand. But let me refresh the court's recollection as to the actual sequence, because the court also made a reference to at the close of the state's case. This information and this objection was brought to the court's attention 2 weeks ago, at which, and I provided the court with case law. I read the relevant matters into the record, And the court took the material back, came back and said, this is too much for me to read. This should have been a Daubert motion. This is not a Daubert motion. A Daubert motion is precipitated when the state offers opinion testimony through a purported expert, at which time it triggers a defense if they have an objection to the expert's introduction of opinion testimony to file a Daubert challenging that. What this is, and as a matter of fact, when we first saw this information, and the state, we were sitting down in the state attorney's office and they were playing this stuff on a screen, and I told the state, I'm like, you can't introduce information from data that was on a text of a phone without authenticating it. I just made that statement. But it is not incumbent upon the defense to try to prepare the state for the introduction of evidence. I didn't even have to alert her to the fact that I thought it was inadmissible without authentication. But when the state purports to or attempts to introduce evidence, at that time, it becomes right as to whether or not it is properly authenticated. I alerted her probably a year before trial. But beyond that, it is not incumbent upon us to piece through the state's case and try to perfect their deficiencies in providing proper foundation for the admission of evidence. When they admit the evidence, if it's not admissible for lack of foundation, that's when the objection is right. Lack of foundation. Then the court rules on the foundation. And the fact that the state is of the position that they can introduce whatever comes off of a phone from whatever app without any foundation is a burden that they carry, and if they fail to meet it, then the evidence is inadmissible. It's not, well, the defense should have told you that this is how you should have done it, which I did, first of all. And second of all, I did alert to the court, and it does not make it inadmissible. It's not incumbent upon me to say, get an expert so I can determine whether or not that expert is sufficient and thereby file a Daubert motion. This is not a Daubert issue. This is an authentication foundation issue. And if they do not have and if that foundation has to be laid by an expert, it doesn't thereby transpose it and all of a sudden turn it into a Daubert issue. If that's what they need to put it in, that's what they need to put it in. If they don't, they don't. But it's incumbent upon the court to make a ruling at the time that evidence is being introduced. This is not a Daubert motion. This is lack of foundation. The courts are clear. You have to establish foundation for this kind of evidence in order to put it in. You can't just, and as I said in my motion, it should not escape the court's attention that the only case that the state found to rely upon was a case out of Wisconsin, which with all due respect completely misses the point. It says, Fitbit's around for a while and everybody thinks it's reliable. So what? As I said in my motion, horoscopes have been around for a while. A lot of people think they're reliable. It doesn't make it admissible. The question is whether or not their acceptance of reliability is well-founded. And that must be established in order for it to be introduced. The state has failed to do so, and it's inadmissible, judge, and re-object.
You start talking about acceptable reliability. That sounds like a Daubert motion to me. What's the state's position?
Your Honor, this is not a type of information that requires any sort of expert opinion. This is not outside the scope of a regular juror's ability to understand. It shows that there was activity and that the phone was moving around at 4 a.m. It shows that the phone was moving around again at 4:40 a.m. This is corroborated by multiple sources on the phone. And pedometers, I think the first case I cited in this case to the court, pedometers have been used since 1967. This is nothing new or novel that requires any additional testimony whatsoever. Based on the data, the state would submit that the activity data is well within the purview of any juror and would be admissible.
Your Honor, just one retort. There are two components, and we're conflating issues. Expert testimony is admissible, opinion testimony, when it helps to a jury to understand an issue. In this instance, we're talking about authentication. which is this information reliable? It's not a question of whether or not they know how pedometers work. The question is whether or not a pedometer produces reliable information. Their internet is littered with instances where these pedometers have different information that differs from reality when it's tested. As I gave you an anecdote of Larry Daniels, our expert, who says his wife plays piano at church, and when she comes down from there, it says she's taken 20,000 steps, because every time she taps, it reflects that there is a step. So in order for the state to advance that and the state, and Your Honor, the case that I provided concerned a static Google map. And the judgment was reversed because the proponent of the Google map did not establish the operability of Google Map and its reliability. A static picture. Here we're talking about the state coming to say he went left and he moved in this direction 70 steps, and then he went 100 steps to that direction and 1,000 in the other direction. Clearly, the risk of inaccuracy is amplified in that type of situation. And so this notion that, oh yeah, but they know what it is. Yeah, but is it accurate? I want to hear a distinction between that and horoscopes. Everybody knows what a horoscope is. Everybody knows how it's purported to work. It doesn't mean it's accurate. It doesn't mean it's admissible. So the fact that it's been around since 19 whatever date is of no moment. The fact that jurors understand what pedometers are purported to be is of no moment. The fact that they do not have any concept or any basis upon which to predicate an understanding as to its reliability and accuracy is of importance. And that's why it's inadmissible.
And again, counsel, you keep going back to reliability and accuracy, and that's a Daubert motion. Authentication is it what the state or whoever the proponent is that what they say it is? Boom.
The case that I cited, there was no Daubert motion, and it was a lack of authentication at the time of introduction of trial. I understand the court's conflation of the two issues, and yes, in this instance, what would be needed to authenticate it would be somebody with expertise. But it is not incumbent upon the defense to go and say, go find an expert so that I can object to it. That's not what it's about. The question is whether or not you can introduce the evidence that you bring in here into a jury. That's the issue, and it's not incumbent upon me to go through her file and determine what she needs to authenticate each piece of information and tell her to go file it, go find an expert to do it so that I can file a Daubert motion as to that expert's opinion. But I've stated my opinion, I've filed my objection, Your Honor, and we stand up. And I just note the cases that I've cited where this error was made have all been reversed.
Thank you. Have a seat. Ready to proceed?
Yes, sir.
How are you going to handle this? I know you're losing your voice. How are you going to handle it?
I'm going to start and I'm going to have Ms. Smith then publish. This was the exhibit that we were speaking about first. Was already offered to the witnesses, states, quadruple, quintuple, and so 5. So I was going to have Ms. Smith start and publishing that, and the intent is to publish the entire document.
How many pages is this?
And where's the witness? Do we know where the witness is?
121.
He's here, as my understanding.
I'm going to get him.
All right, why don't you get the witness and then bring the jury in?
No, it's here.
He's on his way.
Thank you.